Hey,
Morning.
morning, Your Honor.
Morning.
Good morning. So I have you guys on for an emergency motion, madam. I think I see a court reporter here, or do I? Do I
No,
see?
Your Honor, I
Okay,
don't believe
just
you
making
do.
sure. Okay, so this is an emergency hearing. I'll note for the record that it was previously set for an emergency hearing in December, and then the parties, I think, let the court know they thought they were making good progress and maybe they would be able to work it out. And then that didn't happen. And so now we're sort of back to this emergency hearing. I'm going to tell you in advance, I have a very short window of time. I have a murder trial that's ongoing, and I need to get back to it at about 9:15 or 9:30. So we're going to be very efficient. One way that we're going to do that is to tell you that I've read your pleadings. I'm aware that this relates to a roof issue that has resulted in allegedly a leak, and that there would be somewhere north of $7,000 required to repair the specific issue that is causing the leak in the unit that is the um, at issue in this lawsuit. Of course, it's a condo building, so I'm immediately wondering what is the status of the larger issue, or is it something that is really isolated to this unit? Um, and beyond that, it is, I think, Mr. Carlton, is it your emergency motion? And so I'll let you go ahead.
Thank you, Judge. I think you've got a good idea what's going on with the case, and I don't think there's much dispute with the other side about it. It's more of a, so I'll just kind of cut to the chase. There's a leak in the skylight. There probably is further issues in the roof. The problem for my client is he can't rent this unit out because every time it rains, there's gigantic puddles. And I think I attached exhibits of videos and photos with it. So we went about to try to find a solution just for his roof. And it's called crickets. I'd never heard the term before for roofs, but it's basically Ms. I'm sorry.
Brain. It's okay.
Thank you. New Image Roofing's here. We
I
have
would have gathered that because of the new image roofing designation, but thank you.
yes,
Go ahead.
yes. So if you have any technical questions for her, she can answer them. But basically, we would like you to allow us to do this fix, the $7,000 fix on the roof, so that the issue can be solved. Because we keep as you pointed out, in December we had raised the issue. It seemed like there was going to be a universal solution because apparently the whole entire roof needs to be repaired potentially. That's but that as far as to just fix the skylight, we believe that the $7,000 fix would do the fix, and
Well,
because
sorry for interrupting. Let me ask you a couple of questions to make sure I understand. So, one, does your client have the authority to just fix this one thing if it is technically external, in terms of where these crickets would go? Would they go on the roof, which is a common area, or would they be installed in your client's unit?
they would be installed on the roof right
Okay.
around his skylight. That's why I mean, if he could just go repair it himself, we wouldn't have had to
Right.
file anything.
And that leads to my second question, which was the original filing. It was unclear to me if you were seeking an injunction to order the COA to fix it, or if you were seeking authority to fix it yourself.
I mean, the quickest would be for us to fix it ourselves, and so that's the emergency relief we're seeking, Your Honor.
Understood. Okay. Anything else you want to add
I
before
mean,
I?
that's pretty much the fundamentals of it. I think you have a perfect understanding of what's going on.
Okay, thank you. Ms. Jackson, I'm guessing, or
Yes.
okay.
Yes. Good morning, Judge. Thank you. We are here on behalf of the William Oliver Condo Association, and Mr. Carlton has outlined the problem with the roof fairly well. There are some issues, though, Judge, and I will try to address them quickly. One of the things that I think would flesh out the delay or explain the delay in us getting this addressed is that Mr. Sullivan, who is a resident of well, he doesn't live there now, but owns the
Well, he's
unit.
an owner,
He's
and
an
that's what
owner.
matters, right?
Right. He's an owner, and I'm not disputing that, but he's also recently run for a position on the board,
Okay.
which obviously he has an adverse position as a board member given his ongoing lawsuit. So that's
Well,
created
hang
some
on.
different.
You said he recently ran. Did he win? Is he now on the board?
Yes, ma'am. Yes,
Okay, so
Judge.
he's
He
now
is.
on the board as it's constituted effective January of 25?
I'm not sure exactly when
Okay.
he got on the board, but he's currently a
Adam,
board
when did you get on
member.
the board?
December, yes, Your Honor,
I was
December.
just assuming they typically have those elections once a year, twice, or once every 2 years, and so I was
Yes.
just assuming it would have started and effective in January, so.
Whenever he got elected, it was after we filed this.
Yes,
Right.
sir. Okay.
Right. So that said, it's been in an adverse position to the rest of the board members. We've had to form a general counsel for the board, formed a litigation committee to address this. Nonetheless, the condo has had experts go out there to inspect the roof to kind of determine what the actual underlying issue is, because we want to make sure that whatever we're fixing is actually addressing the underlying problem that's causing the leak.
But to be clear, Ms. Jackson, because it is a condominium building, right?
Mhm.
And because we're
Yes.
talking about the roof, there's not a dispute that the roof would be a common element that would not necessarily, I mean, it's not like he's responsible for his tiny portion of the roof. Is that right? Are we in agreement on that at least?
Yes, we're
Okay.
in agreement on that. I think what the board's concern is to make sure that we're addressing the problem so it does not reoccur. And
Okay.
the experts and vendors that we've engaged has identified the coping stone, the building envelope, as an issue that may be at play with the leak. So to that end, the board actually met. The litigation committee of the board has met and is prepared to go forward with repairs to the coping stone. We've identified a vendor, Ameristar, and those repairs actually are going to be to the tune of about $35,000 for the coping stone. In addition, the board has also agreed to make repairs to the roof, and based on our experts' assessment, they're confirming that the areas that need to be addressed are the skylight, the roof drain, and they also plan to build up the curb. What we do need to understand is that the condo is under a warranty, so there are only certain vendors that they can use. So at this point, the plan is to have the work done by Crab Apple Roofing Company, who has done work on the condo before, or another Carlisle approved roofing company.
Okay.
But
That all sounds wonderful, Ms. Jackson.
Yeah.
But I guess the real issue is the emergency part of this motion, right? That the relief that was originally sought, which is what is the timeline for that to all get done? Because if that's going to get done in the next 2 weeks, then probably I don't need to order
Mhm.
the emergency relief sought. But if that's going to take 3 months from now before it even starts, and then the work will take a month, that's a different calculus.
I definitely appreciate the concern, Your Honor, and that is a conversation that I had with General Counsel this morning, anticipating that being a concern for the court. And she has indicated that once the contract is signed, the only other part is to make sure that, for example, Ameristar, who's going to do the coping stone work, is insured, properly insured to do this type of work. And then she anticipates that work can start perhaps within we'll just estimate within 2 weeks of execution of the contract, but they're prepared to sign it. And it's just a matter of making sure that they're properly insured. And I would say the same thing for Crab Apple. So,
Okay.
yeah.
Thank you, Ms. Jackson. Mr. Carlton, here's a question. If I were to order the relief that you seek, right, to allow Mr. Sullivan to do this one-time repair to his own roof, number one, what, if any, concern arises that it affects the rest of the units or that it affects the roof as a whole, number one. And number two, would Mr. Sullivan be looking to ask for reimbursement from the board for having to incur this cost?
To answer the second question, yes, we would
Okay.
be seeking that. To answer the first question, that's why as far as the effect I believe now, I'm not a professional roofer, so I'm relying on my roofer. But what they want, what she's suggesting to be done is something that wouldn't material affect the rest of the roof. It really is solely
Like
focused
some
on
sort of ceiling
the
thing
skylight.
around the
We're basically talking about a
the sunlight.
skylight. Every time it
Right.
rains, the skylight rains. And so that's, so I don't, again, I'm not a roofer, but I don't believe that would cause any prejudice, I guess is the right word, for the rest of the roof by putting in these crickets right around the skylight.
Okay.
And so I would agree if they're ready to go in 2 weeks, I think that's probably would be satisfy us, but that our experience is it doesn't move that quickly.
Understood. So Miss Jackson,
Yes.
the standard on an emergency motion, right, is whether or not a failure by the court to grant the relief that is sought would result in a fundamental, damage that's irreparable potentially to Mr. Sullivan.
Yes.
And what you've laid out sounds like a reasonable solution to Mr. Sullivan's problem that would, one, avoid him taking action on a part of the common element over which he does not have individual authority, and also avoid him incurring a substantial fee that he would then be looking to the condo association to recover. Having said that, Mr. Carlton's point is well taken, which is I understand there's lots of paperwork that needs to be done anytime a COA undertakes to do something like this, especially if it's under warranty. But I think my inclination here is to say that if the COA can make happen what they say they're going to make happen between now and, say, January the 31st, right? The paperwork is signed, the contract is undertaken, a vendor is approved, such that work would reasonably be expected to be undertaken beginning in February, the first week of February. Then that seems like a reasonable solution to absolve the concern of the emergency here.
Yes.
But to be clear, that ruling comes with it the caveat that if on January 31st or February the 5th, Mr. Sullivan and Mr. Carlton come back and say no work has been undertaken, we've asked for contract, we don't even know who the vendor is, then I probably would grant Mr. Sullivan the relief that he's seeking, because one thing I think has been explained to me to some extent is that the fix he wants to use would require access to the roof, but once they get it, it's a relatively quick fix, right? I mean, it would be something they could do in fairly short order. And if I allowed and authorized him to do that, given the lack of timely action by the COA, then the next question would be the extent to which the COA is responsible for the costs incurred in making that fix. Does everybody have a general understanding of what I'm saying? Mr. Carlton, questions?
No questions, Your Honor.
Ms. Jackson?
I understand, Your Honor. I would just add, I don't have any questions. I would just add, we are happy to, and I appreciate the court's concerns as far as the timeliness of the board taking action. And what we can do is check in with the court and let the court know where we are with getting everything done as far as the paperwork, because the
And
concern for the
that's exactly all I'm asking. And it doesn't even need to be formal, right?
Okay.
You can send an email to Mr. Freehoff, letting me know where you are in the process. Of course, Mr. Carlton would be copied so that there wouldn't
Of
be any
course.
ex parte communication. And then that way
Yes.
he's aware of what's going on.
And for the record, Your Honor, Miss Jackson and I have been getting on great. We've
I
been
can tell,
communicating
trust
wonderfully,
me.
so I would not anticipate any issues.
Excellent. So here's what I would like to do, though. If one or both of you, whoever wants to draw the short straw, could please just provide me, because I am in trial. So
Yes.
sometimes preparing an order is a little, I want to get one on record for you timely.
Yes.
If somebody could send me something very brief that basically says, for now, I am not granting emergency relief. that instead what I'm requiring is the condo association to provide documentation and evidence of a contract signed with a vendor with a scope of work and an intention to begin no later than January the 31st, with the idea that work would be undertaken in that first week of February, whatever those dates are. Let me just, to try and be as clear as possible, let me look at what those dates are. So the 31st of January is a Friday, so that works out well. So I would be looking at work beginning or some indication that work has been undertaken or intent to be undertaken the week of February the 3rd through the 8th. Barring that, then I would be receptive to Mr. Carlton coming back to the court saying the COA has not been able to navigate the paperwork and all that stuff that has to be done with warranties and insurance companies and everything else. So we don't have a vendor who's ready to start. There's no hope that any work has started the week of the 3rd to the 7th. And so it's not on the horizon. And I can get you guys, as demonstrated, when you ask for an emergency hearing, I can usually get to you pretty quickly.
Yes.
I'll do that,
That's
Your
going to
Honor.
be
I'll
my
draft the
ruling.
order.
I'm sorry, Mr. Carlton.
I'm happy to draft the order, and I'll exchange it with Ms. Jackson. And,
Excellent. Yeah, just send it to Mr. Freehoff, and if y'all can do that today, then I'll go ahead and get it on file for you today, and everybody will know what they're doing. And then hopefully I won't need to see you guys anymore. And if I do, I will, I guess, see you sometime towards the end of the week of February the 3rd or into the week of February the 10th. Okay?
Thank you,
Okay.
Judge.
Thank you
Thank
all.
you so
Have a
much,
good
Judge.
morning.